Very good afternoon to all of you. Respected Chairperson of this session, Dr. K.P. Upadhyay ji, Moderator to this session, Hitit ji, and all the resource persons, the faculty members coming from different parts of the country, and fellow participants. As we all know that this session is devoted to the topic, the theme, examination reform. Some agendas have also been specified for the discussion, and I will deal with the agenda number 2, the efficiency of prevalent mode of examination, prospective reforms and suggestions. Friends, the examination refers to the detailed inspection of the students. Another meaning to the term examination also refers to a formal test of person's knowledge or proficiency in a subject or skill. In the first meaning, the examination requires a detailed inspection of the examinee, and not in the second, where the examination is just to complete a race course to pass some hurdles and then to acquire some score to pass the course. And this score also depends on the subjective satisfaction of the examiner, even the whims of the examiners. This subjectivity of the present examination and evaluation system, it certainly creates disparity in getting the marks to the students. In the meaning to the word of examination, it emphasizes the taste of knowledge, proficiency in the subject or skill, and it is very difficult and contentious, critical also, to observe that how one pattern of examination can examine the taste of students similarly in all the disciplines or in all the circumstances. This problem particularly happens with the area of legal studies, where the subjects are divided into two, the substantive papers and the procedural papers. The present system of examination, particularly in traditional universities like us, where legal studies are also a part of university system, based on the memory of the students. It is correct that the strong memory may be good for a professional, for a examinee, for a student, for a lawyer also, but it is also the fact that the proficiency can not be tested alone on the basis of memory. And therefore, the pattern for examination of law students should be designed to test their skill and proficiency. The skill sets for law students which should be tested by the examination may be the language comprehension skills, the critical reasoning skills, research orientation, ability to understand the facts, and communication skills. Communication skills will include both oral and written communications. For a lawyer, the written communication should be with professional fineness. It should be very precise and concise also. The examination, which we are talking about the examination, the knowledge of the legal provisions and case law, taste of proficiency in subject or skills, these are significant aspects of the examination or for the examination of a law student. And therefore all should be taken together, not only one. training part of a profession is also the basis for developing proficiency in the skill or subject. We find many times the students who could not score well during their law school life, rather they spend their time in internship with advocates, gaining professional knowledge, are well-established lawyers at different places. This should also be made the part of the examination pattern, and the students should also be examined or tested on the basis of their participation in moot courts or internship. We know that 5-year course has also been launched. It was also the planning of the Bar Council of India that it should be replaced by the 3-year course will be replaced by the 5-year course. It could not be done yet. Either it is 3-year course or it is 5-year course. What we are doing in the examination system, which is based on particularly the memory, we are giving the certain set of questions, and there is no need to participate in the classes to give the answers of those questions. Sometimes we see the students who never attend the classes or who attend the classes very less as compared to the other students who are regularly attending the classes, but they are getting more marks because this is based on only the memory of the students. Other parts of evaluation of the personality of that candidate are not the part of our examination system. And it is just like that we are giving the training of swimming to the students sitting in the classroom itself. And just imagine if those students, those candidates, those individuals who have taken the training of swimming sitting in the classroom, when they will go really in the swimming pool, what would be there with their fate? It is just like that we are developing the communication skills by teaching the rules of grammar. How a person can be best in the communication skills, either it is Hindi or English or any language, who has been taught only the rules of grammar, because it cannot be done without the sound practice of speaking English. And therefore we are preparing those professionals who are increasing the crowd in the courts. Therefore, the 184th report of Law Commission of India, which was on the subject the legal education and professional training and proposals for amendments to the Advocate Act 1961 and the University Grants Commission Act 1956. This commission, this 184th Law Commission report emphasized over the problem method of evaluation, because many bad patterns of evaluation and teaching, because teaching and evaluation, teaching and examination, these cannot be seen separately. These are not the independent parts of the study. Whenever we make any reform in the examination, accordingly we should also take care of the syllabus, we should also take care of the content on which we are going to make the questions. We see that the examination pattern has been changed in Banaras Law School from very long time. The semester system was it has been introduced, though in other law colleges or universities it was introduced later. But after introducing the semester system, we could not change the syllabus in accordance with the need of semester system. The papers which were taught in the yearly annual system examination, the same syllabus has been made the part of the semester examinations. Even some papers we see that there were 2 papers in 2 different semesters. Now both the 2 papers have been put in 1 semester. How we can make the reforms in the examinations when we are not forming our syllabus, we are not shaping our syllabus or the content to be taught to the students in accordance with the planning for making the reforms in examinations. And therefore, the problem system, lecture system was the ancient system, the old system for teaching law students. Then the case study system came into scene. Then the clinical legal education. And clinical legal education is also in the same way as we are giving the training of swimming to the students sitting in the classroom. How can it be possible that a teacher who always studied the theory, gave the examinations in the present examination system, came to join any faculty, any department of law, and now we expect that that teacher will teach the students by clinical study method in clinical legal education. No, it cannot be possible. Unless and until we make the efforts at the root and we address the root causes, only then we can go towards making the reforms in examination. Therefore, I strongly recommend the problem method for the legal education to be included in the study of the students and for the examinations also. Not only one system can solve the problem. Therefore, the lecture system, the question paper shall be in such a form wherein all the kinds of questions may be included. And the students of law should be taught in accordance with that, all the patterns of legal system, of the legal study. Either it is lecture system, that should also be there. And the papers can also be identified, that for which paper the lecture system would be the appropriate system, for which paper the case study system would be the appropriate system, and for which particular paper the problem system would be the weighted system. In accordance with this, the long-term plan should be evolved, and accordingly we should put forward the examination reforms in the area of legal studies. The question papers must have all the aspects, all the patterns. The students must be taught in all the patterns, because the law student or any law professional cannot be made only by teaching the legal provisions. It is sad that law, language, literature, sociology and philosophy, that makes a lawyer. Not only the law, language, literature, history and philosophy, these make a lawyer, and therefore all should be included. It has been done by introducing the 5-year course. So all the aspects of the legal profession whereby we can produce the efficient professionals in the field of law, that should be included. This is my humble submission in this conference, that for making the examination reforms, first we should take up the reforms in making or specifying the syllabi in accordance with the pattern which we want to introduce, and for examination patterns, all the considerations, all the aspects and different patterns of the legal education should be included. Thank you very much.